a situation where you get to decide who presides over your disputes, where such disputes are determined, how, when, and with what applicable law. That is a possibility in arbitration, a very bespoke and elegant mode of dispute resolution. Today on Law Express, we discuss arbitration. Don't go away. We'll be right back after this break, and then we delve into the topic. My name is Noella Seidu, and this is Law Express.
Michael Jangowusu is a private legal practitioner and senior lecturer at the Ghana School of Law and president of the Ghana ADC Hub. Nanya Owusu-Ankuma is a distinguished private legal practitioner with a wealth of experience in her field. She's a proud fellow of the Chartered Institute of Arbitrators in the UK. When she's not immersed in the legal world, Nanya enjoys reading books, dancing to music, and praying. Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
I'm of the opinion that when it comes to commercial transactions, usually arbitration is more popular than the other aspects of the alternative dispute resolution mechanisms. And one may wonder, what then is arbitration? What really is it for the everyday person who probably is only familiar with the court system?
Well, arbitration basically is parties who have a dispute deciding that they don't want to go to court, but instead they'll go for arbitration. And arbitration is just like court, it's private litigation. So you will have an arbitrator who acts as a judge. If you were in court, you would have a judge deciding the case. An arbitrator will decide the case, and whatever the arbitrator decides will be binding on the parties to the dispute, just like you were in court. So essentially, you get someone to decide your case, but you don't have to go to court. You don't have to go into a courtroom with someone wearing a wig and a gown. You still have lawyers representing you in the arbitration. You don't have someone applying strict legal rules, but the parties are able to agree amongst themselves what type of rules and laws they want to apply for the decision to be made. And once the decision is made, you cannot appeal against it.
And the interesting thing with arbitration is that the parties get to choose the person who would be the arbitrator. And so parties have the option to look for qualities that they like. Are they looking for somebody who is well versed in the subject area, is an expert in the subject matter of the dispute? Are they looking for somebody who can give them an expeditious proceeding? Are they looking for somebody they absolutely trust would keep their dispute quiet, private, confidential, and so on? So these are some of the aspects of arbitration.
So to add to that, it's actually a non-contentious way of resolving your disputes, in that you take away all the aggression that people perceive to come with litigation, and you can choose actually more than one person to resolve your disputes. How different is it bringing it side by side to litigation, if we were to pick at one point after the other to just oppose the two modes of dispute resolution?
So let me take one aspect of the one major difference. If you go to litigation, whichever court you are proceeding to will have a set of rules. You will have to follow those rules. In fact, if you look at the way the court decides matters, you could have a perfectly good case, but if you do not follow the rules or the procedure strictly, you could lose on the technicality and not on the merits of the case. in arbitration, even though there are rules, the rules are normally decided by the parties to the dispute. So the parties to the dispute can make up their own rules, or they may decide to follow institutional rules. There are some, arbitration institutions, they have rules.
Yeah.
Now, before parties will select the rules of an institution, they or their advisors would have made sure they are comfortable with the rules. They want to follow those rules, and therefore they know what they are doing. Again, even those aspects of the institutional rules that you do not like, you may derogate from, and take the institutional rules, add to it, take away some of the rules already there, and craft your own bespoke set of rules. Then that would guide your process.
Okay, let me take it this way. Kofi and Ama have a dispute. They want to resolve it. If Kofi and Ama were going for litigation, they'll just show up in a court that they've been told they should show up in. They go, they'll see a judge there. The judge has already been assigned to them. They have no say in who is going to decide the dispute. They enter the court. Now they enter the court, it's not just Kofi and Ama who will be in court. There'll be all different types of people in court who also have cases before the court. They will sit in when they are hearing Kofi and Ama's case. They will all be there. They'll hear what is being said about Kofi and Ama's case. If Kofi and Ama were to go for arbitration, before they go for arbitration, they agree on who the judge should be. So they go there on that day knowing who is going to decide the case. They also agree on even where they are going to hear the case. As I said, with litigation, you are told that go to commercial court 4, and then you go and look for commercial court 4, and then you go there. But for arbitration, the parties decide we are going to have the matter heard in this conference room, and they all go there. In arbitration, it is only Kofi and Ama, their lawyers, and the arbitrator, in this instance, who is the judge, who will be in the room. It's private, it's confidential. Juxtaposing that with litigation, anyone at all, even me, who has nothing to do with the dispute, including the media, they can just come in there, sit there, hear what is being said about Kofi and Ama's case, and decide to do a news item on it. They have no choice. And I think the other thing that's very important for a lot of people is that when you are in a courtroom and the judge decides and you don't like the decision, you think that what they decided wasn't right, you can simply file an appeal. When you go for arbitration, whatever they say is binding on you. The only instance where you can overturn the decision is if there was some aspect of unfairness, or they didn't give you the opportunity to present your case, some form of disadvantage to you. That's the only time that you can challenge the decision. So that's where the key differences are.
I think at the very heart of arbitration is the requirement of consent. So everything is an agreement. The parties must agree that first they want to be bound by an arbitration or by arbitration proceedings, and then they choose who would be in charge of their proceedings. So everything is based on mutuality and flexibility and perhaps choice. How about the issues of costs? In litigation, you know who makes the most money when you go to hire somebody.
Well, so I spoke about the rules already. Most institutional rules will have, regulations relating to how the cost of the proceedings are going to be shared. So you know that unlike when you go to litigation where the government is paying the judge, paying the court staff, the registrars, and so on, one aspect of arbitration is that you pay everybody. You pay for the use of the center, you pay for the arbitrator, you are paying your lawyers as well. So the institutional rules or the parties themselves would decide, are we splitting the cost evenly? Is it going to be a case of loser pays? Is it the case that maybe a certain percentage will be shared equally, and then, depending on the outcome, somebody would bear the cost. Again, you would find that most institutional rules will also give the arbitrator some discretion on how to allocate the cost of the proceedings. So if the proceedings should have taken, let's say, 6 days, but one party or their legal advisors decided to, delay, play tricks, and then it turns into a 20-day hearing, and the arbitrator is sure that these extra days were as a result of the gimmicks and role playing and game playing of this party, they are able in the award to say, I'm sharing 6 days, 3 days cost, but the rest was something that came about because of your behavior at the arbitration, and therefore that is your cost. Reimburse the other side for the extra days and so on. So yes, there's consensus, but beyond the consensus, there's also the discretion given to arbitrators to ensure that, at the end of the day, there's fairness as well.
And just to add to the issue of costs, I mean, Noel, a lot of people complain that arbitration is expensive. And let me just still use a Kofi and Ama scenario. Okay. If Kofi and Ama were going for litigation, whatever they are filing, they go to the court registry. They'll tell them, well, to file this is how much it is. 100 cedis, 200 cedis, they pay, they file it. The case goes on. At the end of the day, if Ama loses, Ama will, the judge may say that, Ama, because you've lost, pay 20,000 costs to Kofi. Okay. That's the end of the issue. When it comes to arbitration, Kofi and Ama will have to pay the arbitrator or arbitrators. Okay. Kofi and Ama will be paying their lawyers. Kofi and Ama will also be paying for all the administrative aspects. So if they go to hire a conference room, Kofi and Ama have to split the bill for the conference room. Kofi and Ama also have to split the bill for anyone who will be typing the proceedings. And initially, Kofi and Ama will split the bill. But if at the end of the arbitration, they decide that, let's say, Ama, you are the loser, the arbitrator may say that because you have lost and due to A, B, and C, you should pay Kofi's cost as well. And in that instance, that means that Ama will sort of be refunding whichever percentage they say she should pay for Kofi. But the interesting thing is that with arbitration, the cost is front-loaded. At the very beginning, you pay all of this money. With litigation, the truth is that if Ama is not happy with the decision, she can go to the Court of Appeal and even go to the Supreme Court. So although in the beginning it seems that litigation is cheaper, the fact that you can go all the way up to the Supreme Court, at every stage you are making payments, and then also the time involved. I think if you weigh that, you'll see that the cost of arbitration is not so much, especially because at the end of the day, you get a binding decision that you cannot appeal against, and your time is also cut short.
And if I may add, there are certain things that money comes by. When you go to arbitration, because it is private and confidential, trade secrets, for example, there are certain types of disputes. If you have it in an open courtroom, trust me, by the time the litigation is done, there will be 101 businesses competing with you, because the dispute might lead to the revelation of your trade secret. Sometimes reputational damage. The fact that certain companies or certain individuals are fighting each other alone may send a signal to their customers or the market that all is not well, when in actual fact it may be something very small. But the fact that you went and you heard this company versus that company, you might even change your subscription or decide not to buy their product because you are not too sure whether one is going to go out of business or not. So this protection of reputational damage, trade secrets, is something that you really cannot pay for. And the other thing you get for paying the arbitrator is an expeditious process. Now, if you go to court, most of the time that lawyers spend in court is wasted. It is only recently that the courts are trying to assign the time that lawyers should show up. So theoretically, you go to court at 9 and you leave around 2 or 3. On a bad day, you could be in court from 9 with your lawyers, leave around 3 o'clock, and would only have done 30 minutes of work. Your colleagues who went to arbitration, if they sat from 9 to 3, all those hours would be spent on actually resolving whatever dispute they took to arbitration. In 2-3 days, 5 days, they are done. 3 years, you are still there. So if you look at the cost in arbitration vis-a-vis the time spent in litigation, you find that cost-effective arbitration by far leads.
I think the issue of time is something that has always been a huge advantage in favor of arbitration. Sometimes you start litigating over something, and within 3 years, the value and the importance of that particular thing is no longer there. It's changed, it's diminished. So the time factor comes in where you opt perhaps for arbitration. You can have a resolution within 3 months. You salvage whatever is left of whatever asset it is that you are fighting over, and then you move on.
Yes, I mean, Nuala, you're very correct, because think about a construction agreement.
Yeah.
You are putting up, let's say, a 3-story mall, and you have a dispute with maybe the person who is supplying you, I don't know, cement or the metal works. If you're going to stay in court, and this is the type of dispute that you need to resolve before you can continue the construction. If you haven't resolved whether they're actually using the right materials that you agreed on under the contract, you cannot go ahead. Now, the problem here is that if you're stuck in court for 1 year, 2 years, trying to resolve that, all that time, the construction project is put on a halt. By the time you resume in 3 years' time, costs of building materials, even the value of the contract might have gone up about two times.
Yeah.
Whereas if you went to arbitration, you can use an expedited process, 6 months. I mean, as long as the 2 parties are dedicated to getting that resolved, within a short time, you can do that, and the project can go on. So that's why you see that a lot of commercial contracts prefer arbitration, because you cannot buy time with money.
I think that in trying to compare arbitration to litigation, we essentially talked about the advantages and disadvantages, I mean, between those two options. Can we look at what a valid, since we are now talking about opting in, what a valid arbitration agreement must have? What are the essential components that make it valid?
Okay.
Yeah.
So an arbitration agreement is like any other agreement. So all those elements we have spoken about, which you would find in a contract, initially must be there. There must be consent. The parties must have legal capacity to enter into a contract.
Yeah.
But beyond that, there are certain aspects of the arbitration agreement which are peculiar to arbitration. Most contracts could be oral and be enforceable. An arbitration agreement must be in writing. And the law defines in writing very expansively, but it must be in writing. It is also not in respect of every dispute that you can have an arbitration agreement.
Yeah.
So the law says that certain disputes cannot be the subject matter of an arbitration agreement. So in Ghana, you have something like the matters relating to the Constitution, matters relating to disputes in which the public have an interest. You have matters like, it's not specifically stated, but in practice, that is what it is, serious crimes. The state has an interest in serious crimes. So you cannot say that we are going to go into this construction dispute agreement. But if somebody were to murder somebody on the construction site, we'll resolve it by arbitration and not reporting it to the police. No, you cannot do that. So you must make sure that the arbitration, the subject matter of the dispute, is one in which the law recognizes that arbitration is applicable. Then an arbitration agreement may also refer to future disputes as well as to disputes which have arisen. Okay. So just like Dania said, at the time that the parties are
happy,
looking forward to making a good deal or looking forward to some
Working
money
together, yeah.
and all of that. They sit down and have this rational agreement. Now, in working out the agreement, a dispute will not have arisen. And they would say any agreement that arises in future. So it is advised when you are writing an arbitration agreement that you draft it broadly, if you can, to cover all disputes arising out of or in connection with the...
To the extent that they are within
yes,
the allowed parameters.
Exactly.
Yeah.
You put it there so that you can, so basically these are the things that you must look for when you are writing an arbitration agreement.
We haven't still exhausted the requirements for a valid arbitration agreement, but it's time for a break. So we'll go quickly, and when we come back, I'm sure Nania will pick it up to fill in the blanks. This is Law Express. Don't go away.
So Michael talked about an arbitration agreement being in writing. How should it look like? And I just wanted to add that, there's a bit of flexibility there because the law actually explains what being in writing should be. It doesn't mean you have to put pen to paper. An email will suffice. And in fact, the law provides that where you have any information that is recorded, whether in magnetic optic form, which means telephone conversation, if you have a record of your telephone conversation when the two of you agreed to go for arbitration, that is valid.
With
nowadays,
social media correspondences.
Well, yes, if it is recorded. So WhatsApp message, for example, if I send you a WhatsApp message saying, Noella, I love our contract, I think we are going to make a lot of money. If there are any disagreements, let's go for arbitration. And you respond to my WhatsApp message.
I send you an emoji with a thumbs up.
With a thumbs up.
Perfect.
That's an arbitration agreement. Or I send you a WhatsApp audio, and then you send a WhatsApp audio back. As long as we can go back and refer to that audio, it's in recorded form. We have an arbitration agreement. And then in terms of the content, I mean, there are some technical differences which we don't really want to go into. But for example, for every arbitration agreement, you have to agree on a seat of arbitration, which is usually like a city like Accra, Paris. Yes, that's where you put that in the arbitration agreement. You also have to agree if you want to have an institution supervising the arbitration.
Or you just have it privately.
Or you have it privately.
You choose an anchor.
Yeah, no one is supervising it, you just go ahead. And I just even want to take the opportunity to mention that in Ghana, we have two very strong arbitral institutions. We have the Ghana ADR Hub, which Michael is president of, and then we have the Ghana Arbitration Center.
We've tried to look at these options and what makes for an essential arbitration agreement. What about the choice of law?
Yes, that's also something that is left for the parties to decide on, especially in international arbitrations, although you could, to an extent, also do it in domestic arbitration. So some countries will call that a non-domestic arbitration. Now, there's the understanding among parties who are savvy that the laws of certain countries are better suited to the resolution of certain disputes than some countries, some other countries or some other jurisdictions. So you can look at the subject matter of your dispute and look around the world and see which country has the best laws when it comes to the potential disputes that are likely to arise.
The fairest.
Yes, you know, the fairest or, certain and so on. So then the parties are able to decide that even though we are seated in Ghana, we may want to apply the law of England and Wales because they have a very well-developed, let's say, commercial law. Or this is something relating to securities and some special commercial papers which only the New York lawyers will understand. So we'll choose the laws of New York State, which is like a country because it's a federal state.
Okay.
Or you want to do an oil contract, you are going to Texas because that is also so, or maybe you are going to Singapore for something where their law is better developed than the other. So
the subject matter is on cryptocurrency.
yes.
And in Ghana, we haven't really explored that widely.
It's not, I don't know if it's even legal, so you wouldn't.
It's not illegal either, so it's...
yes, it's in there. What I mean is, you really don't know.
You don't know what to do with it. It's like
then,
surrogacy law now.
Yes,
Exactly.
you don't have any good guidance,
Yes.
you know, but there are places where you really would find,
Yes,
you know,
established,
developed
Court
laws. So
cases that have
you want to
explained.
use that.
I don't want to jump into enforcement just yet, but that could be one of the considerations.
Yes, I think we should discuss why people choose arbitration in the first place, because that's an important point. I mean, people, you know, if you know about the advantages and disadvantages, but you are still not quite sure in what circumstances should I be thinking about arbitration. And one of the important things with arbitration is that it works very well when the parties are from different countries. So for example, take the case of someone from Ghana entering into a contract with someone from China. The person from China, they are going to supply goods, they are going to manufacture the goods and ship it to Ghana so that the Ghanaian sells it. Now the Chinese person will not want to choose litigation because it means that they will have to come to the Ghana courts for a Ghanaian judge to decide between a dispute between they who are Chinese and a Ghanaian. They always fear that there might be some bias, you know, towards them because they are not from this country, and the Ghanaian courts may be preferential towards the Ghanaian. So in those cases where it's a cross-jurisdictional transaction or a cross-border transaction, where one party is from one country, the other is from the other country, arbitration is really apt so that it takes the case away from the court to a neutral country, and also to a neutral person. Maybe they don't want a Ghanaian judge, and they may not want a Ghanaian arbitrator or a Chinese arbitrator because they may be lean towards the person who comes from their country. So they may choose a Swedish or an English person to decide it. Then the parties are comfortable that they will actually make the right decision. But you know, the beauty and sophistication of arbitration is also that once you get an arbitration award, the person in China does not necessarily have to come to the Ghanaian courts to say that this person, the award that was given to me, that they should pay me 100,000, they haven't paid. So I'm coming to attach their car, their house to sell. Once the two nationals, let's say the Chinese person and the Ghanaian, there's something called the New York Convention. If both countries have signed on to the New York Convention, there are 172 countries that the Chinese person can go to go and enforce the award, which means that I may be a Ghanaian, but I may have a house in London, and I may have a house maybe in Switzerland. If the Chinese person gets an award against me and I am not willing to pay, and he comes to Ghana and maybe they only get my car to attach, and for that maybe they get maybe $10,000, there's still $90,000 they have to find. They can take the award and go to London, and because London, UK has signed to the New York Convention, they can go to the UK courts and say that I have an award, and because you are signed to the New York Convention, I can come and enforce the award here. So go and attach her house in London, and then pay me my 90,000 from it. He can also go to Switzerland and present the same award, and then go and get my assets from Switzerland. Whereas if it was litigation, it is only, the judgment of the court is only confined to the borders of Ghana.
We sampled people's opinion on this topic of arbitration. Let's take a listen to see if they appreciate our direction. And then probably after we react to the Vox Pop, we can discuss state parties in arbitration. And I'm not talking about two states against each other, because then those are two equals, but maybe a multinational company against the government.
arbitration to litigation because I feel like arbitration is much more simple, it is cost effective, and it is also flexible as compared to litigation, because with litigation it is court order, it is much more formal, but with arbitration both parties can decide on things that will fit both of them. So I prefer arbitration to litigation.
Yes, I would prefer arbitration over litigation because it's often faster, more flexible, and confidential compared to court proceedings. Additionally, the parties in question have more control over the process and can choose an expert in the subject matter of their case. And also, the suitability of arbitration depends on the specific circumstances of each case. Thank you.
Okay, so I prefer arbitration to litigation because arbitration is more flexible and confidential, and also it's an easier process. I can get an immediate answer or an immediate effect. Yeah.
Ella, you don't need us here. It seems arbitration is already sold out there.
Yeah, exactly. Very
I just
well read
hope
on
that
it.
as they talk about this, none of them mentioned costs. You know, people think that just like the courts where judges are paid from state coffers, automatically the tribunal in an arbitration will be paid by some agency. The advantages they just rattled out, that is what you actually pay for. So the confidentiality, the speed, the flexibility, and the choice and win-win situation, all that convenience and comfort is what you pay for by splitting the cost or agreeing who bears the cost. But certainly somebody has to pay for it.
So when it comes to what are we paying for?
Yes.
So one of the things that you are paying for is enforceability. As Nania said, you know, especially in the situation where it is conducted under the New York Convention, there are over 100 countries. It's getting close to 200.
Yeah.
Close to 200 countries where you can take the award and then enforce. You are getting the choice of a decision maker of your own, who may be an expert. You are avoiding state courts. Sometimes, I'm not saying state court is bad, but then in international disputes or where you have international parties, avoiding a particular state court may be an advantage. Over time, even though institutional rules differ, the international and commercial arbitration practitioners have developed an international understanding of arbitration dispute resolution. So you buy a certain kind of uniform certainty when you choose arbitration. Unlike the situation where you are going to country to another country to find out what happens in their court. Over time, what would happen in an arbitration proceeding is very well settled among arbitration practice, so they understand what is going to happen and much more. But let me bring in a little, let me add up to a little beyond what we are discussing. Arbitration forms part of the milieu known as alternative dispute resolution. Because you brought in small claims, you would find that in the spectrum of processes, one of which is arbitration, you would find an alternative which is well suited for the resolution of business disputes where the subject matter is not too complex or the value is not too high. You could have something like mediation, you could have fact-finding, early neutral evaluation, and so on. So if you take your dispute to lawyers who understand alternative dispute resolution, they are not just going to shepherd you to arbitration. They are going to discuss all the range of options with you, and then if arbitration is the one that is good for you, they will take you there.
I just had to throw it in because you find that many people draft their own contracts. You know, at the time they are entering into the agreement, all is well. They are not being pessimistic and they are not anticipating any disputes because it looks great on paper. So they think they can dispense with the role of a lawyer at that point. They're likely to download some precedents online and pick clauses from other countries, sometimes with aspects that are not even enforceable here. So they would do this, and when it comes to arbitration, and then they add an arbitration clause in the words that they have found it online.
Exactly.
So they just copy and paste till there's a problem.
I'm sure you have found, you've had this experience of maybe, let's say, private dwelling letting over 5 years.
Yes.
Maximum amount of income that will come, maybe $200,000. Then ICC arbitration, 3 arbitrators.
Yes.
And it's like the amount of money, the total amount of money that...
With a seat in Europe.
Oh, yes. You know, so it's like it hadn't really been thought out well. That's the cost of the process you are signing on to, maybe more than the total value of the dispute.
So
of
that
the
brings us
value
to amendment
add.
of the arbitration clause at that point, where the parties agree.
Okay.
Can they after the fact?
Yes.
Yes,
You know.
but just to bring us back a little, I mean, I think one of the people think that lawyers come in where there's a problem, but lawyers are more important when there's no problem.
Yes.
So at the point where you are entering into the arbitration agreement or thinking about an arbitration agreement, the solution is not going online, finding one and putting that in. That is when you need legal advice. And I have to say, it's not even just going to any lawyer, because lawyers have different specializations. You need to go to an arbitration lawyer to tell you whether the arbitration clause you want to use is good or not.
Yeah, it's time for another break. We would go quickly. When we return, let's talk about amending arbitration agreements mutually. I mean, after the dispute has come in and you realize that you've bitten more than you can chew. Don't go away. This is Law Express.
About amending arbitration agreements. When there's a dispute, it's very, very difficult for parties to agree to an amendment. Even a very small tweak becomes an issue for discussion and quarrel because egos are involved. So I will say that the best time really to craft your arbitration agreement is before a dispute arises. However, sometimes you can't help it. It's already arisen, you need to amend it. Be prepared for opposition for the other party, even if it's reasonable. Because that's just the way it is. They're angry with you, tempers are high, they just want to disagree over even the most smallest things. But if you pursue it, you should be able to. I think one of the things that I usually use to encourage parties who are not willing to amend or perhaps who are being very difficult is to draw their attention to the cost element involved. So for example, we've agreed on 3 arbitrators. In fact, we should just have 1 arbitrator. The other party doesn't want to agree. If you bring their mind to how it's going to affect, that choice is going to affect their pocket, they are more willing to abandon their ego and then choose the sole arbitrator. For example, as well, sometimes when you choose certain, maybe an institution outside the country to regulate or to administer the arbitration, apart from the money involved, sometimes also even the time and the type of lawyers that you will have to hire to be able to apply those different...
We haven't even talked about visa issues. There's no guarantee that all your witnesses and everybody's going to get a visa.
Yes, to fly and everything. And those are, I think, some of the practical aspects that you need to use to convince the other party to agree to amend the arbitration agreement.
I've seen people stick to their guns, stubborn. They get to arbitration, they send the invoice, and they abandon the proceedings.
Most arbitration institutions will try to accommodate parties. You know, all the people I know who act as arbitrators think that they also owe the practice an obligation. And so you find that from time to time, people will take on cases which are paying them very little just to encourage you know, people to resort to arbitration. Sometimes, as Nania said, what may be done is to rethink the dispute resolution procedure the parties have selected. There are times where the parties in the arbitration agreement would have opted for a very convoluted, long process, when in actual fact, this is a dispute that just revolves around the interpretation of a document.
Probably one paragraph.
Yes, but it is important, as Nania said, that at the time that you are crafting your arbitration agreement, you get expert advice so that they give you, you know, at least an idea of what
The implications are.
it involves to get the case from start to.
I mean, to build on what Michael said, I mean, another approach, as he talked about alternative dispute resolution, there are a number of different types. So you can actually have an arbitration agreement, but the parties will agree that before we go for arbitration, let's do negotiation. So you have a representative from your side, a representative from my side, they sit together and try to find a solution to the problem.
Failing which,
yes,
and it's
failing which,
escalated,
they go to arbitration. The good thing about that is that by the time they have those conversations, even if they don't reach an agreement, the issues have been clearer. They would have, sometimes maybe they think that we are actually, you know, fighting over 10 things, but after having the discussion they realize that actually it's only two things that we are really fighting about, and then which means that when they go for arbitration, the arbitrator is only going to be deciding those 2 issues instead of the 10 that initially they had thought was between them, and therefore the proceedings will be shorter, it will be quicker, and it will be less expensive. So you also have to explore ways where you can try, the parties can try on their own to resolve it. There's also mediation, where it's not just the parties, they also bring in a third party, but that third party isn't acting as arbitrator, they're acting as a mediator who is just facilitating conversations between the parties. And because there's a third person facilitating conversations and steering them, the chances are that they are able to reach an agreement. And again, if they are not able to reach an agreement, by the end of the mediation, the issues are clear, and even the mediator sometimes, by talking to them, is able to flag up where the weaknesses in their cases. So if they don't want to settle,
to, you know, concessions,
they may be willing to make some concessions, which really makes the arbitration unnecessary or really makes the scope of the arbitration very small. So these are other ways in which you can, you know, bring in to try and take the costs down.
It's time to address some questions from social media.
My name is Fidelis, and I work in the healthcare industry managing a clinic at Osu. We've encountered a disagreement with the neighboring clinic over shared resources and patient referrals. Should we pursue arbitration rather than litigation to resolve these disputes?
So what's unique about this is that there's no pre-existing contract between
them.
Yes.
So there are times where if the other, let me put it this way, patient care, health care is something that is very sensitive. I'm sure it's likely both institutions may not want their patients or potential patients to know they are fighting over these shared resources. They could explore the possibility of asking the people, you know, writing to the people, indicating the nature of the dispute, and requesting that they resolve it through arbitration.
If they are minded.
If they are minded. You know, we also have court-connected ADR or arbitration, mediation, and so on. So there are instances where, because you don't have a prior existing ADR agreement, you could go to court. And now all the court rules in Ghana require judges to send parties or recommend the use of ADR. So you go to court and you tell the judge, you know, the nature of this dispute is such that it may be more appropriately resolved through an ADR process. The judge will talk to the parties, and if the other side agrees, so that possibility is also there.
Even with the commercial courts, it's actually a compulsory aspect of the litigation that you try pre-trial conversations or arbitration before a different judge who would not be in charge of the main matter or suit. failing which you now
go
escalate it to litigation.
an actual litigation
Yes.
process.
Just to add to what Michael said, I mean, I'm thinking about this, you know, this issue. The main thing is they have shared resources.
Yes.
And I would actually say that perhaps you should think about mediation or negotiation. This is because when you go to court or arbitration, they're going to pronounce on your legal rights. This belongs to this person, that belongs to that person. But because they are shared resources, what you probably need to do is negotiate on how you can share,
those mutually,
yes, mutually share and use it. And in that case, when you go for litigation or arbitration, you are not really going to get a result. They are just going to say, this belongs to this person or that. But with negotiation or mediation, you can actually say, well, maybe if we are sharing maybe a pipeline, you may say, maybe Mondays and Tuesdays, we will be responsible for A, B, and C, clearing the gutter, whatever, and then, you know, the rest of the week, it will be that the other party responsible for it. You are able to reach a middle ground that is workable for
without
both
rocking
parties.
the boat.
Yes, exactly.
Because you still have to coexist.
You have to
Exactly.
Beyond
coexist,
the
exactly.
dispute.
And sometimes what comes out in mediation is that you just might find that despite your differences, you have shared interest. So we are talking
Actually
about
greater than the difference.
Yes, we are talking about patients. Sometimes patients don't present just one disease. So he comes to my clinic. I notice that there's something that you are an expert in. You are able through the mediation to, you know, as part of making your relationship smoother, come to this arrangement of referrals. And, you know, it builds up from there.
Hello, Noella and your team. I live in Oyarifa, and my name is Prince. I'm a homeowner in a residential neighborhood. Recently, a dispute with my neighbor has arisen concerning property boundaries and responsibilities for maintaining shared landscaping ideas. This agreement has caused tension and disrupted our peaceful coexistence. In exploring options for resolving this conflict, I'm curious about how arbitration typically operates in neighborhood disputes like ours. How does the arbitration process unfold, from selecting a neutral arbitrator to reaching the final decision? Additionally, what specific benefits might arbitration offer for both my neighbor and me in terms of cost effectiveness, confidentiality, and preserving neighborly relations?
You want to take it?
Yes, I mean, I think the first thing you've talked about is that you are neighbors, okay? You are not going to abandon your house simply because you have a problem with your neighbor. So you need to ensure that you are engaging in a process that preserves that neighborly relationship. And when you go to court, it's very contentious. But one of the good things with arbitration, at least, is that it's not as combative as it is in court, and therefore you're able to preserve the relationship. And you're also talking about shared landscaping, and it may be something that's very peculiar to the area, or it may be something that really, it's someone who has a good understanding of landscaping, who can really try and help, you know, resolve that issue. And that's where arbitration comes in. If you go to court, it's just going to be assigned to any judge. You don't necessarily know the background of the judge. They may not know much about landscaping.
Unless you also pay for an expert.
To come in,
which is additional cost.
Yes.
But with arbitration, from the very beginning, when you are choosing the arbitrator, both of you can keep in mind that because this is about landscaping, let's find someone who has some idea about landscaping, who can really help resolve this issue. And you were talking about how the process looks like. So if you agree to go for arbitration, the first thing is, because in your instance, the dispute has already arisen. So if you agree that we are taking this to arbitration, the first thing would be that agree on the boundaries of the arbitration. Are we having one arbitrator, 3 arbitrators? Where is the seat going to be? How are we going to appoint the arbitrator? When you agree on all of these things, you start by appointing your arbitrator using the way, you know, the manner in which you've agreed to appoint the arbitrator. Sometimes if it's one arbitrator, you'll agree to come up with a list of 3, and then you all choose in the order of priority. you choose from 1 to 2 to 3 in order of preference, and the one who gets the highest vote will be the one who is appointed as the arbitrator. And then the arbitrator comes in and you decide the process together, and at the end of the day you go through the process and you get an award. With something like landscaping, it's not likely you are really going to be bringing in any witnesses. They'll probably come to your area or to where the house is, have a look at what's going on. Each party will talk about what their issues are, and they're able to decide in a very quick manner.
I think it's a neighborhood, a community.
Yes.
You could get your neighborhood committee chairperson to be your arbitrator. And if it's one of those communities where they have rules and regulations that the people living there must abide by, probably that could be the law you work with.
Yeah.
Yes.
I mean, that's the beauty of arbitration.
And again, going beyond, and I seem to be talking about the other process, because again, they are all intertwined. For instance, mentioning the neighborhood chairperson or committee members, there's the process of conciliation. Yes. You know, sometimes some of these disputes are such that the relationship between the contesting or contending parties is so damaged that they cannot talk rationally to each other. You know, so conciliation is the process where somebody comes in, realizes there's a problem, speak to one of the parties separately about the problem, get to know what their views on the problem is, go to the other side, do the same, and then shuttle between the two of them until it is possible now to bring them together to think through whether we'll use mediation or arbitration and so on. So yes, the other people could first start as conciliators, bring them together, and then they can decide what the best dispute
Although
resolution.
I believe that there's room for conflict, and conflict is good sometimes, I like to say that some of the strongest bonds are formed after conflict. I mean, there's that opportunity to test each other, and then you know everybody's boundaries, then you can have a mutually respectful communication moving forward. Yeah. It's been a great conversation, great. Talking about a very special and bespoke aspect of dispute resolution, which I think is the most elegant mode of dispute resolution. Thank you so much, my co-panelists, for coming by on the show. Hopefully we get to reconvene to pick up the other modes of alternative dispute resolution away from litigation. My co-panelists today have been Nania Owusu Ankoma Saki and Michael Jang Owusu.
Pleasure.
My name is Noella Seidu. This has been Law Express, and we have been discussing the elegant subject matter of arbitration. Until same time next week, goodbye.